If you're the president of the United States, you can declassify just by saying it's declassified, even by thinking about it.
In 2022, we all wondered how Trump's "I declassified it with my mind" defense would actually work in a trial. Well, today we got a glimpse of the answer, just a glimpse. Today, the judge overseeing his classified documents trial, Judge Aileen Cannon, rejected Trump's request to dismiss the charges against him. Now, Trump's lawyers had argued that the Presidential Records Act gave Trump the power to retain classified documents after leaving the White House, thereby protecting him from prosecution. You could declassify them just by thinking about them. But in a 3-page ruling, Judge Cannon said that the Presidential Records Act does not provide a pretrial basis to dismiss any of the charges. Now, while that may seem like Cannon is ruling in favor of Special Counsel Jack Smith, who has argued repeatedly that the Presidential Records Act has nothing to do with Trump's criminal prosecution here, Judge Cannon very much left the door open today for the former president to use the Presidential Records Act as part of his defense during the trial. And that means jurors or the judge herself could acquit Trump based on Trump's interpretation of that law. Back with me is Andrew Weissmann. Andrew, how are you interpreting Aileen Cannon's move here? Like, why not just decide whether the Presidential Records Act is like a legit line of defense?
Which is exactly what Jack Smith said he wanted.
Yeah.
He said, just make a decision. We say that it doesn't apply at all. We want a pretrial ruling. In fact, the rules say they're entitled to a pretrial ruling. Just decide one way or the other for good, not the part of the clip,
not halfway.
Not halfway, which is I'm deciding pretrial that it doesn't apply. Well,
but trial.
Jack Smith is like, well, who cares about that? I care about what you're going to say at trial.
Right.
Why? The big sort of thing that people need to understand, to just be in the weeds for a moment. Once the jury is sworn, double jeopardy attaches, meaning if the jury acquits or if the judge acquits, it's over.
It's finito.
So especially if the judge has the power, once the jury is sworn, to say, you know what, I'm entering a judgment of acquittal. And it can be on a cockamamie idea like the Presidential Records Act. So Jack Smith is saying, I need a decision that it doesn't apply, not just pretrial, because guess what? No one's deciding anything like about guilt or innocence pretrial. That's going to happen at the trial. So I need you to know what your view is at the trial. Why is she not doing it? Because, as Jack Smith said, with that ruling, if I disagree with it, I have appellate rights. I can go up to the 11th Circuit. She is doing whatever she can, in my view, to prevent an appeal.
There is, without getting into all the excerpts from it's a short filing, but she uses some very strong language. She calls Jack Smith's position unjust. And she basically, like, Dirty Harry's it and is like, go ahead, make my day if you want to go to the 11th Circuit and appeal this.
Yeah.
What do you make of that posture in the context of all of this?
Well, you have to remember, she has been reversed twice by the 11th Circuit in scathing language. She really hasn't acquitted herself well, whether you think that it's from inexperience, whether you think it's because she's partisan, or both. My opinion is it's both, that she's both inexperienced and she is consistently ruling in unlawful ways for only one side. And when I say unlawful, that isn't just my opinion. That is the 11th Circuit. So, I think that she's not helping herself in this short opinion by using language that is not really becoming of an Article III judge. And I also think it can be fairly attacked as being inaccurate. And that inaccurate is a charitable way to describe it.
And does that hold water with the 11th Circuit? I mean, do you think if Jack Smith can get to the 11th Circuit through a writ of mandamus or an appeal without getting into the technicalities, do you think he finds a sympathetic audience there?
So that's where it's going to very much depend on the panel. So the 11th Circuit is made up of a number of judges. A random group of 3 is chosen. So you don't really know who that is beforehand. So, that I can't answer. But you always sort of say to yourself, if I'm dealing with judges who are rational and fair-minded, and you sort of have to take that as a basis, it's very hard to look at what she has done and say that's the correct legal answer. The PRA is a civil statute. This is
came about after Watergate, was not intended for this use.
Absolutely. In fact, it was intended for the opposite.
Yes.
But here's the really key thing. It's a civil statute. This is a criminal case.
Yes.
Civil statutes don't apply.
It's not
He's
peanut butter and
charged
jelly.
with
They
a
don't
criminal.
mix together.
Yes, exactly.
Andrew, we were talking about confidence in the judiciary, and I'm all for believing in institutional integrity, but man, Judge Cannon, she tests the bounds of that every day. Andrew Weissman, my friend, it's great to see you. Thank you for your time.
Hey everyone, MSNBC has a new and improved app. You'll get real-time alerts and analysis, live blogs, in-depth essays, video highlights, and the best 2024 election coverage. Download the new MSNBC app. Here's how to do it. You tap on the App Store on your phone. You hit search on the bottom right corner. You type in MSNBC. You click on the MSNBC app. You click on Get or the cloud icon and enjoy it.